Good morning, everyone. Thank you all for joining us on this Friday morning with what is sort of a unique way of doing our caucus. So for those of you who are used to attending the NAIA National Convention, what you are used to seeing is that over the course of the 4 or 5 days of the convention, we have a handful of sessions that are devoted to learning about the legislation and engaging in conversation with one another about what the legislation means, what the implications of various proposals are, and that sort of thing, eventually culminating in a vote in the annual business meeting. And this year, in our virtual setting, we are changing things up just a little bit. So today is really kind of the combination of what would normally be 2 different sessions where you will hear in detail about each of the proposals. You will also have the opportunity to ask questions if you have them about the proposals, or to advocate for or against any given proposal. So that's essentially what we will be working our way through here this morning. So alongside me, who will be helping us walk through this morning, will be Dr. Thomas Howell, who is the eligibility chair of the Gulf Coast Athletic Conference and has been the chair of both our National Eligibility Committee and our Constitution and Bylaws Committee for several years. Dr. Bryce Bernard, who's the faculty athletics representative at Corban University, will also be helping us here today. And Bryce is also on our National Eligibility Committee and our Constitution and Bylaws Committee as well. So as we work through the proposals here today, you'll hear both from me and an explanation a little bit of the proposals, as well as Thomas and Bryce, who will help provide more understanding and implications of the proposals, as well as answer and respond to any questions that you may have. For those of you who may not be as familiar, our Constitution and Bylaws Committee is charged with reviewing each of the proposals that we get submitted to us every spring, about 3 months before the business meeting. And we go through a process where we work through each of those proposals to ensure that they meet the intention of the sponsors, that they are clear and essentially do what they say that they are going to do, and that they don't conflict with other portions of the bylaws. So our Constitution and Bylaws Committee becomes very familiar with this process. One thing to note, if you would like to follow along at home with the legislative proposals, you can go to this link on your screen here of nai.org/fall meetings, and you can see all of the legislation as well as these various legislative resources that are up on your screen. So you can see the proposed legislation itself. We also have what we call a forum, which is where you can go and you can ask questions or provide commentary online as well, sort of like a message room or message board. You can also see some brief video snippets, 1 or 2 minute explanations of each proposal. And we also have a list of frequently asked questions that we put together, as we, as staff and Constitution and Bylaws Committee, as we work through these proposals prior to the business meeting, and we're asking ourselves questions about what does this mean, or how would this work in a given situation. We then record those to try and help you with your own understanding. So those are available to you as well. So know that those are all resources for you to use. But you can also click on the legislation yourself if you'd like to have it up on your own computer as we work through this here this morning. One last note, if you would like to participate in the meeting in the sense of you have a question to ask, or you would like to advocate for or against a proposal, what you see on screen are some descriptions of how to do so, and you really have 2 options. So the first would be if you want to speak directly to the rest of the participants here in this caucus, or speak directly to myself and Thomas and Bryce. If you'll go to participants at the bottom of your Zoom screen, once you click on participants, you should see an option that says raise hand, just like you see the screenshots up on your screen right now. That will essentially alert us as staff that you would like to speak, and we will call on you when we get to that component. Please note that we may have multiple people who have raised their hands at a time, and you may not be able to see that on your end. But so please wait for us to essentially call on you if you've raised your hand, and that's how we'll be able to work through this. This is sort of the virtual or electronic version of coming to the mic in the normal caucus when we're all in the room together. So that's one option. The second opportunity is if you would like to essentially enter your comment or question via the chat function, you can certainly do that as well. So in the chat function, we would simply ask that you direct your comment to NAIA host. You are probably unable to direct a comment that everyone in the meeting can see, but if you direct them to the participant marked NAIA host, that will again help us to just facilitate running this smoothly, and we'll address all those questions that come in there. So we're about to get started here in just a moment, but I'd also like to look to Thomas. Normally Thomas is kind of running this meeting for us, and just due to some of the logistical and technology challenges of all of us doing this remotely, we're manning this from the national office here a little bit more. But Thomas, I'd like to invite you to provide any additional comments.
Thank you, Chesney. All of us have spent some months trying to get used to this virtual format in every respect, and I suspect that many of us, like me, are not fully familiar with it, but please bear with us as we work our way through this, and then bear with me as I work my way through this. Please bear in mind, if you do the raise hand thing that Chesney just mentioned, I do not see that, nor does Bryce. The national staff, however, does see that, and they will intervene, and they will bring the comment or the question or whatever else to attention. So if you raise your hand and I don't seem to be reacting to it, that's why. But it will. Please understand, you will be able to ask your question or make your views known. Bryce, do you have anything you want to add to that?
I think you covered it well.
Okay, with that, let's get started. So,
all right, ready to get started then. We have fortunately, we have less proposals than normal. We have 9 proposals that are still on the agenda. Some of them may require considerable explanation. Others are fairly brief, but we're going to take them in order. And so we will begin with 20B01. This is the first proposal. It has to do with softball frequency of play and medical hardship limits. And the only change here is that it changes from 28 dates to 56 games. Now, since softball is normally played in doubleheaders, in many respects, this doesn't change the rules at all. It does, however, give a greater amount of flexibility because you could play single games on different dates. So at least in theory, you could have softball being played on more dates than you would under the present rules. But basically, 28 dates to 56 games. And that's, I think the intent is obvious. Questions or comments?
we do.
The hardship rule, I mean, it's really a change in terminology more than anything else, but it could have a slight difference in how many dates are used for softball.
All right, we have a question from Joe Glover. Joe, I've unmuted you.
Thank you. Joe Glover, Director of Athletics at Indiana University Southeast, ADA, president this year. One of the things that I brought up a couple times about this one, and I'd like to say that I'm not 100% opposed to it, but I do think it could lead to higher travel costs. I think some of the athletic directors I've talked to feel that more dates being played could also tax already overtaxed resources in the spring and sports information and training. And, it's a little bit easier for, double headers on 28 dates and let's say 14 dates with double headers and another 28 dates a single game. So just something I wanted to bring up overall. I think we just need to consider that it could lead to some additional costs for us as athletic departments. Thank you.
Thank you, Joe. And I'd also like to thank you, Joe. You also reminded me of something, which is that if you do ask to speak or enter a comment in the chat, if you'll identify yourself by saying both your name and either the institution or conference that you represent, that would be helpful. Thanks, Joe.
We have a question from Ashley Wolochow.
Ashley Wolochow, University of Houston, Victoria Athletic Director. Not really a question, but more to echo Joe's comments, especially early on when teams are playing in tournaments. It's not uncommon for softball teams to play 3 or 4 games on a date in some of those early season tournaments, and I think the unintended consequence of this, trying to align more with baseball, will be higher travel costs, as Joe, because you're spreading that tournament out over 3 days instead of 2, or an extra day to get those games in because of that. So I agree with Joe. I think we're going to be dealing with that end of it next year at this time if we pass this.
Thank you, Ashley.
And I'll share a comment from Megan Sanger in the chat box that says this mimics the NCAA maximum games for softball. A comment from Barry Freed. This could also lead to more missed classes.
Okay, thank you for those, everyone. If anyone else has a comment or question, or would like to raise your hand to speak, please do so now. We'll give it just another moment before we move to the next proposal. So now is your opportunity. One quick reminder for those of you who may not have been through this process with us before. Today at the caucus, as you can see, we've got the opportunity to all kind of learn together about the various proposals and their implications. On Tuesday at the business meeting, we will hold a vote and make a final determination on each proposal. But prior to voting, once that proposal has been motioned onto the floor, we can also engage in discussion at that time. So you will have one more opportunity if something else occurs to you after today, or provide commentary at that time as well. Either of those can also take place at the business meeting. Anything else, Brenda, before we move to the next?
Ashley, you raised your hand again.
I did. I guess the only other thing, and Chesney can help clarify if I'm mistaken or can't remember correctly, but the other thing is too, our schedule creep committees are meeting in spring hasn't really addressed the issues with baseball or softball yet, if I'm not mistaken. So that might be something to wait on, or at least consider waiting on before we approve this, is if some changes come out of spring or out of that committee for the spring.
Yeah, so for everyone else's knowledge, what Ashley is referring to is that we have a current group involving leadership from our Athletics Directors Association and Conference Commissioners Association, and we'll continue to engage more directly with our student athletes and Council for Student Athletes, as well as our Council faculty athletic representatives. And so all of those groups at kind of a leadership level together are evaluating what we have sort of lovingly referred to as schedule creep. But in other words, this idea that taking a look at our regular season formats, and as some of them have seemed to sort of creep out over the entire academic year over time, but also what is the impact on our student athletes in terms of their experience as well as their health and wellness. What is the impact on their academic experience, so missed class time or academic performance? And then certainly from kind of a logistical standpoint of what does that look like in terms of burden on support staff and faculty, as well as what is the cost implication there. So there is a study on all of that underway. As you can imagine, it's a fairly large study, so it's definitely taking us some time, and we're still a bit on the front edges of that. So that group is evaluating these various things that Ashley just mentioned and referenced. So there could be some recommendations coming out of that group, but we would not expect those to come until sometime in 2021. So Ashley is exactly right that there could be some references that are specifically related to even the proposal that's in front of you here today, but nothing that is on the floor for discussion or review at present. Okay, anything else on this one, Brenda, before we move to the next?
Just a comment from Michael Gavin from Texas A&M Texarkana, and his comment is that costs can be controlled by each institution, just as we currently do in today's situation.
Thank you, Michael. Okay, hearing nothing else or seeing nothing else come through the chats or the hands raised, we'll move on to our second proposal here this morning.
Okay, I think those of you listening, this is a perfect example of the kind of thing that the caucus is intended to do, to have people think about the consequences of the proposals and so forth before we pass them. So I think that's an indication the system is working. Of course, when the actual business meeting comes about, if the proposal hasn't changed, those of you who want to raise those questions would have the opportunity to say something about it again, because of course, obviously not everybody who's sorry, at the business meeting will have been at the caucus. All right, let's move on to the second proposal. And the second proposal has to do, basically, it is the addition of scrimmages in the off season, so to speak, for volleyball. Those of you who are familiar with soccer has something essentially this precisely this same kind of thing. So volleyball has asked for the additional scrimmage dates to be conducted after the end of the fall term, to be played only on the weekends and other non-scheduled class dates. It does add the possibility of more scrimmages than is currently allowed. Anyone want to raise a question about this or speak for or against it?
One other thing I'll note to this, Thomas, is that as it relates to this proposal, as Thomas mentioned, we have some other sports that similarly have some additional scrimmage dates that might be played after the typical championship season. Note that they are described in terms of scrimmage dates, which means that you could play multiple scrimmages on that particular date. It also does require that they are weekends or non-scheduled class dates. So if you have classes on a Friday, but you want to hold a Friday night scrimmage, this proposal that you see in front of you would not permit you to do so as 2 of these additional dates. That's a pretty frequently asked question we get related to some of the other sports that have a similar setup currently.
So question from Megan Sager, would these scrimmages have to be played after the end of the season?
So yes, they would, Megan. They would have to be played, well, I should say they would have to be played after the end of the fall term. So that is intended to relate to your fall academic term, which may often line up with the end of your volleyball season. Obviously, this year is a little bit of a weird year that we are all in right now, but traditionally, and you can see that the effective date would be August 1st of 2021. So traditionally, the end of your fall academic term would also correspond with the end of the traditional championship season.
There's a point that I probably should have made about the first proposal, and that is to say that it references medical hardships. Now, the proposal is written as the rule currently exists. Now, most of you are probably aware that we do have a proposal, I believe it's number 4, that will change the hardship limitations. And if the proposal number 4 does change, and well, we'll go through what that does. But if the rules about hardships change, then this rule would also be changed. In other words, we would adapt the wording in this proposal to whatever is subsequently passed. All right, are we ready to go to number 3?
Okay, no further questions coming in through the chat or raised hands at this point on BO2. So I think you're right, Thomas. Let's move on to 20 BO3. Okay,
number 3 has to do with wrestling. And basically, as you can see, largely the exception here is to allow students to prepare if they have the opportunity to participate in such things as senior nationals or Olympics or something like that. Basically, it allows the preparation for that within limitations to not count against the students' playing limits. One thing that is perhaps worth looking at a little more closely is that obviously you cannot wrestle by yourself. You have to have somebody working with you, so to speak. And so the provision allows individuals to have practice wrestling with 1 teammate per session. Now, that doesn't mean you can line up 10 and wrestle all 10 of them on the same day. You can pick out different individuals for each session, but there is a provision for wrestling that actually is allowing somebody who's not on the road to the Olympics to participate in the practice in order to help somebody who is get their preparation. The criteria for this is specified in exception number 2. The current conference champion holder plays at the most frequent national invitational champions or previously qualified for a national team.
One additional note to that comment that Thomas just made regarding the ability for someone else to practice with the Olympic qualifier, for example, that person would need to be a teammate. So their coach or coaches and 1 teammate can be involved in the practice. It would need to be a teammate from their current institution. For those of you who are familiar with our rules, engaging someone from outside of your own institution will always constitute a competition of some kind. So in order for it to fall under this exception and not count towards the team's frequency of play limits or count as a competition of any kind, that kind of practice partner would have to be a teammate from their current NAIA team.
I see there is a raised hand. Let's see what that is.
Christian?
Christian Oberquell, Montana State University Northern Frontier Conference. I see this is submitted by the Women's Wrestling Coaches Association. Is this for men's and women's wrestling both?
No, since it doesn't say that, you'll notice that the language as far as men's wrestling has been changed. The original, as the rule exists now, it says men's or women's wrestling. Now the men's and women's wrestling are distinguished from each other in the listings. And no, this does not apply to men's as written.
So, and actually, Thomas, I think that here, as it relates to this proposal, what we've had to do, and Thomas is right to notice the distinction in wrestling, how we have separated out men's and women's. And this particular exception down below, Lindsay, here that we're reviewing exception to is specific to wrestling in general. So elsewhere, we've had to specify and separate out the two wrestling sports, the genders between men's and women's, similar to how we've done it at other times in the sense that they operate slightly differently and on different timelines.
We have a question from Ed Lowe, and he asked, does it have to be the same extra person to practice with the entire time?
No, it does not. As Thomas mentioned earlier, it could be a different person on each day of that 4-week run up to the event. It does not have to be the same teammate every time, but it is limited to one teammate per session.
A question from WB Carlton. If a student athlete is talented enough to qualify for the national or Olympic team, what is the reason to add the 3 other criteria to the exception?
So that's a great question, and I'll be happy to speak to it from my understanding of the sponsor's intent, but we may also have some other folks on with us here who represent one of the sponsors. So if, as I kind of walk through this, if I misstated or am not complete at all, I would invite them to also chime in here. So my understanding is that the thought behind that is you'll notice that the 3 types of events we're talking about, so U.S. Senior Nationals representing USA Wrestling or representing a national or Olympic team, the first 2 criteria, we have an understanding of what that looks like in the United States. We have an understanding of what the level of talent is needed to qualify for U.S. Senior Nationals or representing USA Wrestling. But we also, as the proposal says, it also applies to the international equivalent. So you could represent another institution's national team, or if they have a comparison to USA Wrestling, for example. While we believe that this exception should extend to those other countries or students representing other international countries in those sorts of wrestling events, we don't necessarily know what the level of competition is that's required. So what the wrestling structure looks like in that particular country. So my understanding of the sponsor's intent was by placing these 3 criteria for the individual student that they have to have missed. So that they're a current conference champion title holder, they have placed at the most recent NAIA National Championship or Invitational, or they've previously qualified for a national team. By putting those 3 criteria in there, it ensures that the student also has achieved a certain level of qualification and therefore sort of qualifies for this sort of exception. I believe it was intended to just ensure some level of consistency across the fact that we may have various countries with various sort of standards. But again, I would invite anyone from either of the sponsors, if I've misstated that at all, to please feel free to chime in here. We'll give it just a moment here, as I know if anybody's typing into the chat, it can take just a moment.
Chesney's already corrected one of my misstatements in that this does apply to the sport of wrestling in general. And I stated, I think otherwise, not thinking through what I had said, but she's already corrected a misstatement that I made in introducing this.
Okay, so we're seeing no further comments in the chat box or raised hands, so I think we could probably move on to 20B04.
Okay, 20B04 has to do with the seasons of competition, minimum participation. In practical fact, what this is comes from an effort to get around the hardship rule. Essentially, this is going to abolish the hardship rule, except for people who are coming from non-NAI institutions, and basically put a across the board 20% of the maximum allowable number of intercollegiate contests. If you go more than 20%, whatever that figure is, and it depends, of course, on the number permitted for each individual sport, then you're charged a season of competition. If 20% or less, and you're not charged a season of competition. And so basically, we believe that there won't be any need for hardships anymore, per se, in other words, or at least a limit. If you haven't gone over the 20%, for whatever reason, then you're not charged a season of competition. It also has removed the criteria for unattached. And so in a sense, we're dispensing with two of the more specific rules about hardships and unattached. The hardship rule would still apply to people coming from a non-NAIS institution. But otherwise, both of those areas, the criteria for hardships will not apply to people within an NAIA institution. And as 20, it will simply be, did they participate in more than 20% of the contest? And unattached, basically, those criteria no longer have to be specified. Again, the criteria, just to make clear, this does not give an unattached individual the right to participate in an unlimited number of contests without getting a season charge, because that will get into the fact that although we wouldn't be charged for varsity competition, this gets into elite level competition. In other words, if the student reached the level of elite competition, they would be charged a season they would be charged a season for reasons other than the fact that they were unattached.
So as you can tell from Thomas's description, this is a fairly complex proposal, and there are a lot of different components to it. It's seeking to do a lot of things. The Competitive Experience Committee, as many of you know, has been working for a few years on taking kind of a deep dive into this entire rule, or the entire way in which we charge students seasons of competition. And so the proposal in front of you aims at one really large key piece of that, which is providing a way for students to participate in some amount, 20%, of intercollegiate competition while representing their institution before they get charged a season of competition, which what that does is it gives all students across the NAIA a consistent and equal amount of play that they can participate in before they're charged. As you heard Thomas talking about the unattached exception, that is something that has consistently been tweaked and changed and adjusted a little bit over the years. And I think all of us who work with that recognize that it can be a bit complex or challenging at different times to ensure that we're all applying it the same way or understand how it applies in a particular situation. So part of the sponsor's intent here is to essentially remove or eliminate the unattached exception as we have known it, as it stands today. And by providing the 20% approach, it essentially allows all students that leeway. It provides all students some consistent leeway in which to play before being charged. You'll note that in exception 3 here, they also want to ensure that all students can participate in national or Olympic team trials or competition without being charged a season of competition, no matter how many events that might, in total come to. If we rewound about 10 or 11 years to when the NAIA instituted the unattached exception in the first place, this note about representing your national team was a big driving factor for why we had an unattached exception in the first place. So the sponsors felt like it was really important to ensure that that kind of remains unlimited, so that students competing at that level can do so without being worried about its impact on their eligibility, but really felt like the rest of the unattached exception, or the way that it has kind of come to be known and used in recent years, could use a little bit of a revamp, which is why you see the unattached exception as we know it today, essentially removed and replaced by this 20% approach.
We make one other point, and that is to make clear that this is not ex post facto. In other words, the people who have been charged a season in previous years will still be charged a season for those previous competitions, even though under the new rule, they would not be charged for the thing. As consistent with the way we've always enforced changes in NAIA rules, this does not backdate. It does not go back and suddenly forgive seasons that have been charged previously. If the people were properly charged a season under the rules existing up until this point, that will still remain. They will not be able to get rid of those seasons.
We've been asked to speak to the start date for this rule.
Okay, so in case anybody couldn't hear that, we've been asked to speak to the effective date for this rule. So the effective date is May 1st of 2021. You'll note that it then goes on to say, as applied to eligibility decisions for competition starting August of 2021. So basically next academic year. The reason it is written in this specific way relating to May 1st is because the Eligibility Center begins to issue decisions for the 2021-22 school year. They begin to issue those decisions at the beginning of summer, or in other words, May 1st. So we want to ensure that the bylaws allow the Eligibility Center to begin applying this rule, assuming it was to be passed, beginning in May. But to Thomas's point, this is not ex post facto. It does not apply to any competition that is happening during this academic year, during the 2020-21 academic year. It would not apply really until the following academic year. We just want to allow the Eligibility Center to essentially be consistent in aligning their determinations with the rules that we will all begin to play by coming should this be approved. That is a really good point. And I do want to mention something, as I know there have been some comments that have come my way about the special exception that is in place for this year, this COVID year that we are currently in. So as many of you know, for this current year only, our National Eligibility Committee and Competitive Experience Committee recommended to our Council of Presidents that we allow all student athletes in all sports to compete in up to 50% of the maximum allowable limit in their particular sport before they are charged. And the Council of Presidents approved that. So that is a one-time sort of emergency exception to the rules because of this COVID situation that we are all in. It applies only for this year. So it would not continue on into the future. And likewise, this proposal that's in front of you would not in any way change what's happening already for this year. This proposal, if it was approved, would just come into play really starting next fall in terms of how most of us would think about that. Bryce, I want to look to you also. This is a pretty complex one, and I know there are lots of angles to it, so I want to make sure that Thomas and I aren't skipping over any pieces. What are we missing?
No, I think you hit it. I think one of the questions that came up on our campus was that this current year, students can play up to 50% of the games. The exclusion from the NAIA financial aid limits is 20%. So there is a window, the 20 to 50% window, where a student could compete and have to be included on your varsity limits.
Yes. So that's a great point. Yeah. Yeah, and I want to emphasize that for just a moment, because that's a relatively new change that maybe not everyone's tracking on, which was originally we anticipated that this bylaw proposal would be heard and voted on in April of 2020, so this past April, before COVID hit us all. And at the same time, on a parallel path, our Council of Presidents, which oversees and controls our financial aid policy, that they would be reviewing a proposal that was in front of them to also change how and when we count financial aid towards your team limits. So the proposal that was likewise in front of the Council of Presidents was to say a student athlete's aid won't count towards your team limits until that student participates in more than 20% of the contest. So the same contest limits that you see in front of you here today. We anticipated that both of those would be voted on in April of 2020, and if approved, go into effect in fall of 2020. Obviously, we had COVID hit us all, and so we were unable to vote on this proposal prior to now. So what it causes is a little bit of a disconnect for the short term, at least, in the sense that that COP financial aid proposal is in place already. That has been approved by our Council of Presidents, meaning that this year and for the future, a student athlete's aid won't count towards your limits until they play in 20% of games. As I just described, for this year, a student won't be charged a season of competition until they play in 50% of games for this year only. What this proposal, and once we vote on this proposal, we will know the answer to what happens in terms of seasons of competition in the future. So starting next year and beyond, if this proposal was to pass, it would mean that starting in fall of 2021, both the seasons of competition and the financial aid limits would be equivalent if this was to pass. Brenda, are we receiving other questions or comments?
No further questions or comments?
We'll give it just a moment here if you have any additional questions or comments.
Dawn has a question, and let's see, I can ask you to unmute. Go ahead, Dawn.
Yeah, I'm looking at exception number 4, B, where it says hardships cannot be requested for students who are incapacitated in the last regular season game. I'm wondering if this is specific to that exception only, which seems to be an injury that happens at a non-NAIA member, or would that apply to like an NAIA freshman who gets into the last game of the season for the first time and gets his or her knee blown? Is that the intent? I'm just not sure what the exception restriction is there for exception 4B.
Great question. So I'll take a first run at it and then look to you here, Thomas. So that's a great question, Dawn. So traditionally, every student and the rules we're operating under, or minus COVID, the rules we've been operating under have said that a student is charged a season of competition as soon as they step foot in a game. They play 1 pitch, 1 minute, they're charged a season of competition. From a medical hardship perspective, what we have said is that if a student suffers a season-ending injury or illness and is incapacitated for the rest of the regular season, and they have also played in less than 20% of the contest, they could be returned that season of competition. But there was this caveat that says, if you're injured, if you sustain this season-ending injury in the last regular season game, you can't really get a season of competition back. You're not eligible for medical hardship, because the thought process was you didn't miss out on anything. You may have broken your leg in the last game of the season, but you didn't miss out on anything because it was the last game of the season. So you were not eligible for medical hardship, even if you played in less than 20% of the games, if that was when your injury or your illness occurred. So now, as you see it brought forward into this proposal in front of us here today, as Thomas described, for the most part, we wouldn't expect to see very many medical hardship requests because all students would be would not be charged a season of competition until they play in more than 20%. So Don, to your example about the freshman student who happens to get in the last game of the regular season, as long as they're under that 20% limit, they would not be charged a season at all. So the only place that the medical hardship provisions will even come into play at all moving forward, if this was to be passed, are for those students who are at a non-NAIA institution and who do not receive a medical hardship from that other athletic association. And then they transfer into an NAIA school and they're seeking to regain that previous season. So in that case, we would then be able to apply our NAIA approach for medical hardships. And that's the same as what we do today. So with that in mind, what we've done is just carried over the existing way that we think about medical hardships and said that for those non-NAIA injury students who transfer to an NAIA institution, these would be the limits or the requirements that we apply. So in that situation, the piece about a student who's injured in the last regular season contest, if that's the case, they would not be eligible for medical hardship under the NAIA rules either, purely because it is the last regular season contest.
Okay, so just to play that out, I understand that. So the story problem would go something like there's a baseball doubleheader, and game 1 of the doubleheader, a kid gets hurt, he or she is eligible for a hardship if they needed it. But if it were the second game of the doubleheader on the same day, they couldn't even ask for it. So part of my question is it says it cannot be requested. It eliminates any opportunity to even consider if there's something extraordinary out there. I'm a little concerned about that language, just that there's no avenue, but it still is a very forgiving piece of legislation. I understand. Thank you for your time.
And one, to that point, Don, as always, I'm going to not look at Bryce and Thomas on my screen while I say this, but as always, an institution can request an exception to the standard rules if they feel like one is warranted for some reason. So if there was some sort of situation like that, there's always kind of that as a fallback opportunity.
Except this expressly says it cannot be requested. So that would, I would think that would legislate against your comment there. Oh, great, wise one.
We have a question from Lori Kohler.
Lori Kohler at Crossroads League. Just wanting to make sure I understand for this current COVID scenario, we could have someone who would count toward our financial aid limit because they've played in, say, 40% of the games, but they would not be charged a season of competition because they did not play in 50%. Is that correct?
Yes, that is correct.
Okay.
For this year only.
Right.
Okay, a comment from Marcus at Mid-America Christian. His question was if a student plays, say, the first 10% of the season, but has to take a break and then competes in the last 10% of the season, as long as they don't compete in 20%, they can get this exception.
That's correct. It doesn't matter. The sequence doesn't matter. You just look how many contests they participated in. If it's not more than 20%, then no season.
20% and also no postseason, which would include conference or national postseason events.
We have a few questions from members concerned about pitchers.
Okay, so great. Pitchers in baseball is kind of a unique situation in terms of that particular position. Obviously, as we all know, it's common. Take your starting pitcher for them to play consistently in the sense of being in the pitching rotation, but not play in every single game. So it's certainly foreseeable that as you get towards the end of the season, you may have several pitchers who have not yet competed in a full 20% of the contests and therefore wouldn't be charged a season of competition. That has definitely come up in conversation about this proposal, and this is a general approach. And we have talked with the Baseball Coaches Association leadership, and they are certainly aware of it and in fact have raised the concern themselves. In terms of how to think about it differently for pitchers, at this point, we do not have a suggestion or a recommendation from that group. So at this point, I think they're willing to sort of say, let's see how this plays itself out and we'll continue to think about it. So they have not provided a suggestion or a recommendation to the sponsors about how to tweak it for baseball pitchers. I think we all recognize that that is a possible or a likely outcome even as it relates to baseball pitchers. But at this point, there is no specific recommendation about a way to change it for pitchers, meaning the standard rule would simply apply to all student athletes, pitchers included. Anything else coming through, Brenda? No. Okay, so Thomas.
Okay, we're ready to move on to number 5. And number 5 involves the progress rule exception for non-intercollegiate competition. And basically what it amounts to is that it's an exception to the progress rule. Obviously, many of you have encountered the thing where the situation where people might come in with 1 or 2 previous seasons of competition, particularly international students. So they're going to be playing their 3rd season and suddenly they're looking at having to have 48 hours or maybe even 72 hours. And that's, since they have not been in school accumulating credits, that's really an insurmountable obstacle. Well, this gives 1 year for an entering freshman been charged 1 or more seasons of competition for non-intercollegiate participation will be exempt from meeting the progress rule for 1 academic year, 2 semester or 3/4 terms at an NAI institution. Applies only to the student's 1st year at the NAI institution. So it gives some leeway. It does not allow a complete forgiveness. That is to say, if somebody comes in with 3 seasons, they're not going to be able to effectively they're still going to have a pretty considerable hill to climb, but it applies a greater flexibility than current rules do as far as applying the progress rule to people coming in with seasons charged for non-intercollegiate participation.
So maybe it helps. An example, a student is charged a season of competition for outside competitive experience, but they've not attended college. They come to your institution and they are allowed under this exception to compete immediately, even though they haven't accumulated 24 or 36 hours for their second season of competition. To play their third season, they have to make up all of that. They have to get to 48 hours in a year to play the next year at your institution.
As we talked about this with the Constitution and Bylaws Committee, Bryce's example is right on. And I think one of the comments that was being raised is this would allow flexibility to go ahead and bring in that student and allow them to begin competing. It would be really important that athletic staff and administration are being proactive and looking ahead for the student and recognizing how many hours they will need to play in that next subsequent season of competition, and make sure that you're taking the steps with the student and guiding them appropriately to be enrolled in the right hours and kind of do what they need to do to be eligible for that following season of competition. So this would be something where it provides flexibility, but will require some proactive preparation.
A concern raised from Kim Hayes. The concern is if a student has been charged with 3 seasons prior to identification and only has 1 season left to play, they would not have to catch up if they're only competing in their next season. This is not specific to those charged 1 season of competition.
That's correct, and that's a loophole that has been commented upon.
Mm-hmm.
Theoretically, bring in somebody that you know has 3 seasons of competition, only intending to play them 1 season and then forget about them, and that could happen. There's no question about that. That is a loophole. Whether it's a sufficient loophole to block the adoption of this is a decision that the membership will have to make. Like many other NAI rules, it can be abused, and there is potential for abuse in this rule.
One comment from a member has asked, suggestion would be to allow that if only 1 season has been used prior to identification. Anymore, that we are opening up for widespread abuse of a student competing 1 year and leaving. Does this meet our academic mission for our organization?
Appreciate the comment.
This could be corrected if that's you think of it as a correction, either by asking the sponsors to change the wording so it removing the or more phraseology from the rule, or doing it by amendment on the floor. That's a possibility. If somebody wants to move to amend the proposal, they can do that, or the sponsors could amend it without having a formal motion on the floor. But again, as it exists now, that's the points that have been raised are perfectly valid.
Drew Watson.
Yeah, Drew Watson, Southeastern University. I was a member of the Competitive Experience Committee when we discussed this. And I would just give you the reason that this was presented and is a proposal at this point is we were hearing a lot of cases where student athlete, for the most part, international student athletes were being recruited, brought in, given scholarship, enrolling, and then getting an eligibility decision from the eligibility center that they were being charged a year or 2 and then were not eligible that year. So coach has done his due diligence, bring a player in, and then they've got to sit. And so, the way that you're reading this here is a compromise in that you're being asked to give them 1 year, but not that they don't have to catch up. So they still have to catch up, but it doesn't penalize those coaches and programs who recruited, did their due diligence, did their research, but had a player at student athlete charge a season and has to sit. I would support an amendment to take away the loophole. I do agree that that would be abused, though.
And Marsha Lashley has her hand raised.
I concur with what Drew was saying. I was going to mention that the intent was what we historically have seen come through in coming from an institution that has a large population of international students. Many were getting charged with 1, maybe 2 seasons of competition and having to sit. But I would also be willing to amend it to say if limit it to 2. I would not want to limit it to just 1 previous season of competition being charged, but if we limit it to 2, I would be in favor of that amendment, but would like to talk to the committee about it before that amendment is made.
And for those of you who may be a little less familiar with our process and how this all normally plays itself out at the convention, it's not uncommon that questions or clarifications, things like this, come up through the course of conversation and at the caucus. And all of that is good feedback for the sponsoring committees to hear. And so it's not uncommon that we may see some tweaks or adjustments to various proposals between now and the time we get to the business meeting, in this case on Tuesday. So it's an important reason to, when we come to the business meeting on Tuesday, to pay careful attention, and we'll be sure to highlight any changes or friendly amendments that may have been made to the proposals during that time.
This may not even be called for, but I do want to make a comment about the due diligence phraseology there. I would think that a coach, as part of due diligence, would check to see whether an individual coming in would be likely to be eligible. And I think that's something that you would want to look into, as to if you are pretty sure the student is going to have seasons of competition charged, part of your due diligence would be to make sure that student understands coming over what's going to happen to them.
Drew, you have a question?
Well, I saw that there were a bunch of questions that came up over the last amendment, and I just wanted to say, as a former member of that committee, the 20% not charging a season of competition solves many more problems than it creates, and I would hope that membership would not vote down that bylaw because there are certain issues with it. I would encourage that we vote it in and then fix it if we see issues that come up. And that was discussed by the committee. There was and if you remember, if you were at any of the sessions that talked about that legislation in the last couple of years, there was originally a piece in it that said the 20% had to be used in the first 50% of the season. That did not make it out of to this bylaw proposal. But this certainly can be fixed if those loopholes raise their ugly head. But I believe that this legislation solves so many more problems than it creates.
And Mike Daniels.
Yeah, thanks. And I don't want to speak out of turn here, and so I don't want to muddy the waters. But if maybe the national office can address this year, at the end that we go through these proposals as it relates to season competition and 50% rule. As you all know, at the national office, I've sent back and forth emails as it relates to the Golden State Athletic Conference in the state of California. But I don't want to muddy the waters here. So I know Drew just went back and addressed that bylaw number 4, and Chesney had mentioned the 50% as it applies to this year, but I think there's some clarification that's needed, and maybe that's appropriate at the end for the entire group.
Appreciate that, Mike.
Anything else to add on proposal number 5? Hearing none, I assume we're ready to move on to proposal number 6.
Just a moment, Thomas. I think we have one hand raised still on proposal number 5.
Rob, I've unmuted you. And
yeah, this is Rob Ramsey from Friends University. I had a follow-up question to what Drew was saying as to why it didn't make out a committee that it could be not completing more than 20% of games, but not past the 50% threshold of the season. I know the NJCAA at least used to have a rule that worked pretty well. That's were the boundaries to the rule.
Drew, I'd invite you or other members of the committee to speak to this piece.
Well, Rob, I would say that that was discussed vigorously in committee. I think that maybe Marcia can kick in here too. It just didn't make it out. I mean, it was talked about, and I think the reason that it didn't come out, and again, Marcia and any other members of the committee can help me on this, but in those sessions that we had, the last few conventions where we talked about this bylaw and this idea, most of the questions we got or the pushback we got was on that piece. Why would you go first 50%? Shouldn't it be this? I think when we looked at it, we realized it may be a problem, but felt like it might affect the ability for this to pass. So we took it out. Marcia, is that accurate?
That is completely accurate, but we did leave in there so we made sure to keep in there postseason play.
Right.
So if they participate in postseason play, there's charged, even if they've never competed all year and they participate in postseason, they will be charged a season of competition. That was kind of our compromise.
I'll just jump in here as well. This is Ellen Ramsey. I'm the staff liaison to the committee. Based on various committee discussions, I believe that the complexities of application of that 20% within the first 50% of the season was the big hurdle there. There are still concerns about the ability of members to do tracking just on the 20% limit there, and adding that additional layer of complexity was the big concern. So Marcia and Drew are exactly right. The ability to use the 20% at any point during the regular season, but still keeping that postseason component was the compromise basically that they decided upon.
And to give a little bit of history, and we, for the past 3 or 4 years, it has bothered some members on the committee, including myself, that you have sports like wrestling and track and field who can compete unattached for a significant amount of the season and thereby gain competitive experience but are not charged eligibility. And so I think the first thought there was to take that away from them. But as the conversation evolved, we just thought, well, instead of taking that away from them, because that is something that's built into their sport across all associations, is why don't we take some of the philosophies that the NCAA has started trot out there with the red shirt year and expand that opportunity for everybody. So a wrestler, can compete unattached for a significant amount of time. A basketball player steps on the court for 1 second, loses a year. Committee members just didn't think that was fair, and this is the way that we addressed it. And as I said, I think it solves so many more problems. And then the football coaches had a bunch of proposals that came out over the last few years to try and help them manage the balance between the numbers they're expected to carry on the roster and retaining those numbers by getting people in games. I mean, there were proposals like, hey, if a game's out of hand, 28 points or more, we get people in, that doesn't count. I mean, and you talk about a tracking nightmare. And so this helps in that way as well. So as I said, this solves many more problems than it creates. And I would encourage the membership either to pass it and fix it or to request an amendment to this that includes the stipulations on when it can be used.
And a comment from Brett Simpson. He has indicated that the automatic charge season for competing in postseason may not have been clearly communicated or has really resonated with the membership, as most coaches, of course, have really commented more on the 20% to allow for a season not to be charged.
but are not cluing in on the postseason piece.
It's a good comment, and Bryce did speak to that earlier. And one thing I'll just kind of emphasize there: any participation, according to this proposal, any participation in NAI approved postseason results in a season of competition, no matter how much of the regular season the student participated in. So playing in a single game in NAI approved postseason would charge the student with the season. That includes national championship play. It also includes conference play, assuming that your conference tournament is used to qualify teams or students to the national championship. As an example, in some cases, kind of more few and far between, we may have a conference that has its conference golf tournament early on in the fall semester, and that's when it chooses to host its conference golf tournament, but it's not used for qualifying to the national championship. That would not be considered postseason at that point in time, but sort of as a general rule of thumb, conference postseason is also considered NAI approved postseason. Thank you, Brett. That's a good clarification. Seeing nothing else coming through the chat or questions, I think we can move on here. I would also invite you all, as you continue to think about this and have more discussions, the individual caucuses that various groups are having throughout the course of the day is another opportunity to sort of have further discussion or test out conversation, as is the online forum. That's another opportunity to ask questions where we'll respond to them or to advocate for or against proposals. And that's visible by anyone in membership who's interested. So with that, Thomas, I think we move on to 20B06.
Okay. Number 6 basically is not a change in the rules. It's simply a change in the way the eligibility is certified. At the moment, basically, if the registrar has to provide specific verification that a student is a graduate student and thus is meeting the provisions of being a full-time graduate student as opposed to the 12. Now, in effect, the registrar does this the registrar is supposed to, in any case, certify that all the individuals on the form are taking the amount of hours that they are required to take in order to be eligible. So the registrar, in signing the form, was actually already certifying that somebody has 6 hours. She's certifying, or he's certifying, that that individual is nevertheless meeting the basic number needed to allow eligibility. So this just simply takes out the need to add an additional documentation or verification of that.
Our registrars will appreciate this one.
Give it just a moment for any questions or comments to come through, but seeing none so far. Okay, let's go ahead and move on to 20B07 regarding repeat courses.
20B07 continues to manipulate or to try to revise the repeat rule, which has been revised a number of times in previous years. In this particular case, it has to do with a student who has a requirement, either as part of a general education or degree completion, to pass a course with a certain specific grade. At the moment, basically, we say if you pass with a C, it's going to count, and if you take the course again, it's a repeat and you can't count it. This allows a student who has a grade, whatever it is, that is not sufficient to meet that requirement to repeat it one time and count it for the purposes of the 12-hour rule and for the 2436 rule. I do emphasize this is a one-time repeat. If somebody, let's say, got a C, needs a B, took the course a second time, still got a C, then it's tough. The next time, if they had to take it again, they would not be allowed this repeat. A one-time opportunity to raise a grade in order to meet the requirement in order for general education or degree completion. Questions, comments?
Okay, let's move on to 20B08 regarding recertification.
Recertification 20B8 simply increases the time limit that you have between the semesters, basically from 21 to 30 days in order to recertify, or in the case of an interterm, it adds some additional time as well, the 10th calendar day following the close of the interterm. It expands the period in which, after a term is completed, in which you have to certify eligibility and in which the student retains eligibility at that time, unless and until the eligibility certification is filed. You've got 30 days. After the 30 days, you have to file within the 30 days. You have to file within the 10 days. It just simply, it doesn't change the rule per se. It does increase the time limits involved. Some of the argument about this has been that a school particularly may close down over the holidays and be unable to meet the 21-day rule or somewhat similar with the interterm rule.
So from B. Carlton, why 30 days? Why is 21 days not sufficient enough time?
I think that probably goes to what Thomas just addressed, and that we've just heard from some institutions or conferences based on the way that their campus procedures work and align with the academic calendar and breaks and that sort of thing, that they would just prefer a 30-day time period rather than a 21-day time period. Their experience has been that that cuts it pretty tight.
I have heard individually that some schools, for example, are moving to finish their, for COVID at least, to finish their terms before Thanksgiving, and in which case you'd have the Thanksgiving holidays or the Christmas holidays in which perhaps the offices are closed. That obviously the 30 days would not entirely solve that problem either, but that's kind of a general sort of situation I think people are thinking about.
Any other comments or questions?
I haven't seen anything. Are we ready to move, Chesney?
We have one comment from Michael. There are times when instructors have separate dates from the end of the term to submit grades, which may pose a problem. So the concern is when instructors are able to submit grades after the end of the academic term for the calendar.
So I think if I'm understanding that correctly, it's just the difference of particular professors, which could exist very well today, even under our current structure. So that might be an argument for why an extension to 30 days can be helpful, purely because it gives the institution, and really, I'd say in many cases, the registrar's office, as they're collecting all of those grades from various professors, a little bit more time just to ensure that they're getting all of the grades from the various sources, and then able to incorporate that academic progress and coursework into the eligibility certification process.
Couple of hands raised.
Okay. Couple of
Yeah,
hands
yes,
raised.
this does allow additional days in which somebody could play and could allow an ineligible student they know is going to become ineligible to, it hasn't been officially noted, but they're well aware that the student is not going to be eligible. It does allow them to compete a little longer. That does allow this.
Terry Harris, I unmuted you.
Yes, this is Terry Harris, eligibility chair for the Red River Athletic Association. Because of the addition of the interterm notation, it would seem as though, following up on what Thomas just said, it allows the student in an interterm course to complete that course before having to be recertified, and therefore potentially extend his eligibility. In other words, he needs that interterm course in order to be deemed eligible. And so that addition of the interterm note, I think, addresses that issue as well.
And Lori Kohler?
I just had a question. Our interterm stands alone. So if I'm understanding this correctly, we do not need to file eligibility for the interterm?
Lori, I'm sorry, I was just trying to make sure I understood your question. So what this proposal does, it doesn't change the way in which you certify currently for your interterm. What it does is it provides a little bit more clarification to following the close of the interterm, when you would have to have those students certified by to continue to compete. So there frankly was some vagueness previously or in our existing rules about what the time limit is for the close of an interterm that either stands alone or attaches to the fall, and when those students would have to be recertified. So this proposal clarifies it to say that for those interterms, you could have an extension of 10 calendar days or the 30 days, whichever is later, but that would be the timeline for when your students would have to be recertified to be able to keep competing. It doesn't change anything else about how interterm is certified, nor does it change an institution's ability to select whether you want your interterm to stand alone or attach to spring or fall.
So if our fall semester, I'm thinking basketball, if our fall semester ends, say, December 17th, and then our interterm stands alone, would I have to file eligibility upon the start of our interterm? That's what we've typically been doing, which is like January 6th. So it's less than 30 days from the end of the fall semester.
Yeah, so if it's standing alone, the certification that you're needing to do prior to the beginning of interterm would continue to be the same as what you do today. That would all continue. So then at the end of the interterm, whenever that is that occurs, you would either count 30 days from December 17th or 10 days from the end of your interterm, whichever is latest. You'd have either of those options, the more forgiving one, for when you would have to recertify before those students could continue to compete into essentially the spring.
Okay, I got it.
And a question from Joe Glover.
Yeah, Joe Glover, Director of Athletics, Indiana University Southeast, ADA President. Correct me if I'm wrong, Chesney, but this doesn't change the fact that if at any point that we're in the post, it doesn't even really matter. At any point that we find an athlete is ineligible, that athlete stops competing immediately. So regardless of how many days there are to certify, 30 days, 21 days, once we find out grades have posted and a student will be ineligible, they're ineligible immediately. We don't wait until we certify them 21 or 30 days later, correct?
Yes, and you see that in that last sentence there, that it's not highlighted, but the last sentence of the paragraph, that's language that's currently in the bylaw and would continue to be in the bylaw unchanged, frankly, whether this passes or fails. You're exactly right, Joe. If you know with certainty that that student is ineligible, they need to cease competing immediately. The recertification window is really intended to give you just some time to figure it out when you're unsure, is I guess how I would phrase that. So for students who need to be recertified, or even if you think that the student may end up being ineligible, but you don't know with certainty, it gives you that time to figure it out with certainty. But if at any point, like you said, Joe, you become certain that the student is ineligible, that last sentence would say that that student should no longer compete.
I hate to sound cynical, but I'm sure you know perfectly well that some people will deliberately make sure they don't find out officially that a student is ineligible. And I'm simply pointing out that can be extended. I agree exactly what the rule says. There's no question about that.
Any other questions coming through, Brenda? So we'll move on to 2009 relating to amateur code and name, image, and likeness compensation.
Okay, are we ready for the last one?
I think we are.
All right, the last one is the amateur code, and it shall we say, dramatically liberalizes the acts permitted by the amateur code. This, of course, is moving with the times, as I'm sure all of you well know. The NCAA has been dealing with this kind of thing, allowing students to be compensated and for certain reasons in certain ways. And in fact, this rule makes a statement, but it also, if you will notice, gives flexibility for the NAI to adapt to further court decisions or laws or whatever the case may be. We're just moving in a very different time as to what constitutes a violation of amateur code. Certainly permits a number of things that would not have been permitted before.
A couple of things I'll note about this proposal. So in addition to the key piece, as Thomas mentioned, which is allowing students to receive compensation, currently, compensation is what is prohibited if a student is to promote commercial product or enterprise or public or media appearance that would also reference their status as a student athlete or their institution. In addition to that, it also does two other things. You'll note that what's on screen right now, Article 7, Section C, this is not a substantive change. Rather, this is purely some additional wording for clarification of what Section C does and essentially does not do. So this is not a change to this section of the bylaws, but rather now that we could have a situation where students are able to accept name, image, and likeness compensation, we felt like we needed to clarify Section C a little bit further. And then as you continue to scroll down here, you will see this additional provision that we have included related specifically to the name, image, and likeness compensation. So what this is basically an emergency provision that would allow, in an emergency, for our Council of Presidents in consultation with the National Coordinating Committee, which oversees amateurism, to amend this section and only this section of the bylaw if it was deemed absolutely necessary. And what we essentially mean by that is this is an area where state and federal laws are changing and changing rapidly. We're seeing a lot of that happen across the country. And we recognize that some of that is happening at a fairly rapid pace. It's on a fairly rapid timeline. And so we could find ourselves in a situation where a particular state's laws, for example, may change and would require, or would, I guess a different way to say it is, would prohibit an NAIA school in that state from preventing name, image, and likeness compensation in a particular manner. And so we want to ensure that if that's the case, our goal is to allow NAIA institutions at all times to be able to abide by both state and federal law and NAIA rules at all times. So if we found ourselves in a position where it looked like the state law was maybe changing and it was going to change and go into effect faster than we as the NAIA could operate on our normal timeline, which is to go through this process that you're taking part in today, and normally have a business meeting each April. If we had to move faster than that, it would allow our Council of Presidents and National Coordinating Committee to amend our bylaws on an emergency basis. It would also then require the next opportunity. So in other words, that next April, we would bring forth any decision that had to be made to the membership to essentially validate that or determine what is the appropriate approach forward. So it's essentially intended to be I think of it as kind of a safety net, only to be used if we find ourselves in a situation where our standard timeline would cause a challenge. And then you'll note as we continue to scroll down that there are just some other changes, relatively minor in language, but in this case, giving the National Coordinating Committee, expanding their scope slightly just to ensure that they are also permitted by our bylaws to review any failure of student athletes in their requirement, which the current bylaw or the current proposal says that a student athlete would be required to notify their administrative staff on their campus of any name, image, likeness compensation they were receiving. So we wanted to ensure that we appropriately enable the National Coordinating Committee to review any such instances like that. And then the final piece of the provision, similarly, or in the same vein, goes on to just describe in a little bit more detail that a student who fails to notify their administrative staff on their campus about name, image, likeness, compensation, that could be something that is then reviewed by the National Coordinating Committee. Any questions or comments on this proposal? One last thing I should have mentioned at the beginning, which is we did have an open forum discussion on Monday regarding this topic, and any attendees were able to hear a brief presentation about why this is essentially coming forward and coming to light, as well as a panel discussion with Jim Carr, our NAI president and CEO, and sort of de facto general counsel, as well as Dr. Tim Fulton, who is the president of Oklahoma Panhandle State University and represents the Council President's Executive Committee, along with Fred Watts, who is the vice chair of the Association of Student Athletes and a student athlete at Concordia, and then also Jill Harder, who is representing both the Athletics Directors Association, but also as a member of our National Coordinating Committee. So we have that recorded and is on the website if you would like to go view that to understand more about the thought process behind this. And it is just like all the other materials we've referenced, it is at nai.org/fall meetings. Other comments and questions, Brenda?
There was one question regarding the use of the term school in the new proposal. It seems to encourage use of an institution logo in any endorsement or promotion.
So in regards to that question, I'm not sure specifically which statement within the proposal that the commenter is referring to. But as you can see in the portion that is on your screen now, what we have essentially done is we've not specifically changed the language relating to their institution. It's been stated elsewhere and is kind of moved back up here, and that's why it's all highlighted. But the same typical language applies, which talked about relationship to their institution or status as a student athlete. So it's not, I think the question was asking, are we trying to promote that the student utilize their school marks? And that's not the intention. However, there is not a restriction on that being done. So the bylaw proposal in front of you does not prevent a student from using or from, let's say, wearing a school jersey, something with a school mark on it. It would not prevent them from wearing that as they promote a commercial product and are paid for it. Now, that said, as an institution, we get questions, or we've received questions about what if it's a company or a product that my institution does not support, or that goes against our mission, or those sorts of things. There will certainly have to be some discussions that occur on each campus if this was to pass about how you want to educate your student athletes regarding what is appropriate and in connection with your institution's mission, or where there may be some challenges, whether that's because it's a competing sponsor perhaps, or something where the institution would not approve of their logo or marks being utilized. I will say that that's something your institution can determine how to put some additional restrictions around, but the NAIA proposal does not do so in a sort of comprehensive fashion that would restrict all students or all schools. Another thing to think about in that conversation that would have to be had is state laws. Those state laws that are being proposed and passed on name, image, likeness right now are addressing this in slightly different fashions. So what might work for an institution in one state might not be quite permissible in another state. So there might have to be slightly different approaches there, which is another reason that the NAIA provision in front of you today does not address that and essentially leaves it unrestricted at this point. Other questions or comments?
So concern from one of our members is that in the state of Georgia specifically, their institutions do not allow their employees to do this. So how can we allow our student athletes?
So I think that is similar to what I was just referencing, which is as an institution, you could choose to place additional restrictions. What this would do is permit it across the NAI. So currently is prohibited across the NAI from any NAI student athlete receiving compensation for use of their name, image, or likeness. So this would essentially permit that. It wouldn't force it. So if your institution is in position and it's in compliance with your state laws to be able to restrict that in some particular manner, you'd be able to do so. So that's one place where I think this gets a little bit challenging sometimes to think about on an individual school by school basis, because every school is dealing with not only some of their own institutional standards, for lack of a better phrase, but also your own individual state laws and state structure. So that would certainly have to be part of the conversation there as well.
So a question from Dennis McDonald. Should we consider monitoring the amount of money paid to a student athlete at the NAI level to study if the competitive advantage are being gained? It has to be reported to the school. Why not simply report the same information to the NAI?
So Dennis's question goes to, I think in shorthand, could there be a maximum value or a cap placed on name, image, and likeness compensation? And I understand the thought process behind that. And that's something that certainly came up in conversation with the National Coordinating Committee of Points. One challenge with that, I'll say, is that various state laws, again, only 2 or 3 have been passed thus far, but several others, dozens of other states, are in some process regarding legislation at a state level on this. And different states have language that would permit some sort of maximum cap like that, or in some cases prohibit any sort of maximum cap on the dollar amount there. And I think the rationale behind that is essentially allowing students to sort of own or gain control back over their name, image, and likeness. And so a cap on the value of it could essentially go against that philosophy.
Okay. We have a question from Ashley Walchow.
Yeah, just for clarification, does a student athlete have to report the income to the institution, or just the fact that they have that opportunity?
Can you repeat that, Ashley? I think you cut out for me for just a moment.
Under that point, it says a student athlete receiving compensation must report it in writing to his or her athletics director. Is that just the opportunity to receive
Okay, if I caught you that time, Ashley, I think you were asking, is it the opportunity or actually the compensation? And what the bylaw proposal requires is the actual compensation. So from this bylaw, it would not require the student athlete to report to you as the athletics director every single offer or opportunity that they came across, but it would require that they report to you any actual compensation they received. So essentially any offer that they took advantage of. Now, as an institution, if you in many cases with NAI rules, you're permitted to apply stricter readings of this at an institutional or conference level. So at your institution, if you chose to work with your student athletes and require that they report to you any offer of name, image, likeness compensation, you would certainly have that opportunity. But that is not what's actually required by the proposal in front of you today. Any other comments or questions?
Those of you who have participated this morning, please, and if you are not the voting delegate particularly, please make sure that whoever is going to do the voting, people, colleagues that you know from other institutions, if they have questions about these proposals, to please email them in so we can be prepared to deal with them, and also any interpretations that came out of this meeting might change a person's view of these things. do what you can to help us communicate, because of course, unlike the convention, there's not going to be many times to meet and whatever else and say, hey, we heard this at a certain meeting. So extend your opportunities for communication.
The last thing I'll add as we close up here is just throughout the course of today, there are several individual group caucuses. So that's your opportunity to essentially meet with your peers and your various associations to discuss these proposals in a little bit more detail as you would like, as well as to take a straw poll, which will essentially indicate this is how the athletics directors, for example, feel about a particular proposal. And it's an indication to the rest of the membership how your particular peer group feels about any given proposal. So we have those throughout the day. That schedule has been posted online. And those straw poll results will then all be shared at the business meeting next Tuesday before the vote is taken on each proposal. So the business meeting is next Tuesday, October 6th at 1 p.m. Central. So we'll look forward to seeing you all back together again with us then. Thank you all so much for your time. We appreciate it and enjoy the rest of your Friday.